back. Let's do this. You know how it goes down, based on the facts and the facts only. So we're gonna bring this to you from Fat Cop up there. And what it is fundamental rights. It actually comes from fundamental fairness. All right, and then under fundamental fairness comes fundamental rights, which comes about due process, and there's the procedure for due process. So basically, it means that if they violate any part of due process, it goes down to there where your substantive right kicks in, right? And they say your substantive right is considered so fundamental that it enjoys protection even if they are not explicitly mentioned in the Constitution. So what that means is basically is saying that you know, under the Constitution, under your birth certificate, you have what you would call the fictitious person that they use in court. So when it goes to your substantive side, it goes to the live person. So if they violated that due process and that man-made nonsense, okay, even though they follow certain laws and that, but they violated the process of it. All right, so that brings about fraud on the court. So that's basically torts. Your substantial right kicks in. You say, nah, you can't use that. That's fraud on the court right there. You can't use that. So your live individual, live natural living man, natural living woman rights kicks in. This is something that you're born with. No government gives it to you. You're actually born with this. And you got to stand on that. No, I'm a natural living person. You're not using that on me. And when you do that, that vetoes their decision. But you got to show the injury of that, which is the act of omission, which brings about a violation or failure to do something. Okay? It's either an act or an omission. That's the injury. How was you injured? It was your life, your liberty, or your property. As a civil servant, it's your property. Your job is your property. Okay? That's how it goes. Like I said, you got to use what they use against you back against them and hold them accountable under their oath of office. All right? And I'm out. Later. Back. You know what time it is, based on the facts and the facts only. All right, we're going to deal with this document right here. All right. Now you got to remember. All right. This is supposed to be representation under signed contract agreement. Now, when you get a chance, just press pause and read it. But yet and still, you got to understand something. And the key thing is, how did that grievance coordinator let it take place? All right, as far as going to court, when the officer filed the complaint under whistleblowers protection. If it's under whistleblowers protection, you can't take no adverse actions. Now I'm gonna show you in two more of these jump offs how that grievance coordinator, who's a litigation attorney, who's supposed to be working for you, I'm going to show you how he's working with the other side. Why? Because if you're a civil servant, there's a certain process they must follow. And if they don't follow that process, that's a breach of due process on both sides. That's a breach of due process on the side of the employer, and there's a breach of due process on the side of the union representation. So they knew what they was doing, and they deliberately delayed it to go past what you would say is 2 years under whistleblowers protection and also 3 years under whistleblowers protection. That would be under civil service, and that would be under the state. But yet still under US 42, Nah, man, there's no statute of limitations on that. So you got to prove the injury. And the injury is a act or omission. And how you go to that is you got to go to the substantive side. So which would be your natural living person. Or you can't say person because a person is a corporation. But your natural living man or natural living woman side. How did they injure you? The key is your life, your liberty, such as money and all that, and your property. The job is your property because it's a permanent position. All right, I'm gonna show you a little more. You know the deal. You got to use what they use against you back against them and hold them accountable under oath of office. All right, and I'm out. Later. I'm back. You know what time it is, based on the facts and the facts only. So what we're going to do is we're going to use their document, all right? Because it's the letter from the grievance coordinator that he was writing to the commissioner or the president of the corporation. But the key thing is, see right there? It says New York State Department of Civil Service. This is the manual for disciplinary actions. Now, key thing it says right here is offense must be substantial. The offenses must be substantial. And there's the definition right there. Please pause so you can read. Okay? So if the officer did anything, it must be substantial. Now, let's just go with the first fact, the time of attendance. Wasn't the time of attendance caused by the probationary hospital police assistant deputy director at the time? Where he gave the directive for the officer and the captain not to let the 201 officer park in his assigned parking area under signed contract agreement. Let's go to the next fact. We got a supervisor who gives the officer a directive to respond from location A to location B, but under signed contract agreement, the officer has to respond to location A. Respond to his work assignment, which he did. Now, once he responds to his work assignment as per the schedule, any alterations from there, the supervisor must provide transportation, which she failed to do. She also talked to the officer while he was off the clock. So it was 15 minutes before 11:45. All right. But she's supposed to send transportation. She failed to do that. So the act of insubordination is a no-no. Then we get the last one, where he said the officer was boisterous. Yet he didn't say that he was boisterous, because the tour commander was boisterous to him, and he responded that same way towards the officer. I don't see that in your contract. I don't see it in the contract. So you have no substantial evidence. So once again, you got to use what they use against you back against them and hold them accountable under office. I'm back. Let's do this. You know how it goes down. Based on the facts and the facts only. So once again, let's get to this document. All right, because this comes from the union. Now, what we're going to do is we're going to use their document, but within their document, we're going to use that right there, which is New York State Department of Civil Service. And this is the manual on procedures in disciplinary actions. So let's go over here on the retaliatory actions. The appointing authority must not take disciplinary actions or disciplinary or adverse personnel actions because an employee disclosed information regarding a violation of rules all laws which creates a presence, a danger, or presents a danger to public health or safety, Okay? Okay? And it says see subsection 75B for which basically tells you they can't do nothing. Right? Now the safety part is when the individual, the probationary hospital police deputy director, took his motor vehicle and accelerated it at the officer on the grounds. While the officer on the clock or off the clock, doesn't matter. He did it on the grounds. So once the officer reported that to supervision and they sent him to report it to the EEO, he did, and they did nothing. All right. Now, even though the officer went outside, you have to give the employer a year. You have to give them up to a year to basically have a corrective and preventive actions meeting, which she stated she did, and she didn't. She didn't do no proper notification, the EEO. All right. But this is the procedure they must have followed. All right. And this you can find in this right here, you find right there in that booklet. So they failed to follow any of these procedures. So the grievance coordinator was supposed to also say, did you follow any of these procedures? No. So basically this case is thrown out. We need to know why the union grievance coordinator didn't follow this procedure under signed contract agreement. Okay? That brings about what? Deceptive practices? Like I said, you got to use what they use against you back against them and hold them accountable under their oath of office. All right? I'm back. Let's do this. You know how it goes down. Based on the facts and the facts only. So once again, we're going to use the representing unions document that was from that grievance coordinator who failed to use that right there. New York City's equal employment opportunity policies. So, when the officer made the complaint in reference to the probationary hospital police deputy director using his vehicle in a reckless and endangerment manner, okay, which also constitutes reckless driving, New York State Traffic Law 1212 and New York State Penal Law 12020, and didn't even interrogate any officer. I've got officers off the clock. What's that? 135-60 under intimidation, right? And coercion. Yeah, that's 3 laws right there. Do we got to go to the stalking law that he sat there and waited? Based on the fact that the officer made the complaint to supervision, and supervision sent them straight to the facility's EEO. We question the EEO's actions on her failure to follow these procedures right here, which is in that booklet. You could PDF that booklet and you can find this in that booklet. Okay? Since you want to hide and play the machine, not a problem. My dad gave me a bunch of tools. You're going to take the machine apart. You could PDF all of this. You could PDF all of this. Everything you could just download. Read with understanding. And hold them accountable for their actions under their oath of office as an employee. Okay? Your actions in sending the letter to New York State Division of Human Rights is a violation of Mayor Executive Order number 16 under investigations. Like I said, you don't come in with your own nonsense. You use what they use against you back against them. under their oath of office and hold them accountable under their oath of office. And I'm out.